Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn that subscription. For today's coverage, for all you people who were sad that the Amber Heard trial is coming to an end, good news, everyone! There's a whole new Amber trial waiting to start, because the insurance company has filed for declaratory relief because they don't want to pay. And so this could be a thing now with motions and practice and memorandums and all of it. Could go on for years, maybe, depending on how things develop. Who knows? But yes, there's a whole new lawsuit in town. It has been filed by the insurance company in California because they'd like to not give Amber Heard money very much. So this is under declaratory relief. So just a little bit about that. One of the things you can do is you not only have to sue on the defensive, you can sometimes sue on the, or you kind of can sue on the offensive. You can also sue on the defensive, both ways around. I kind of screwed up which one was. So you can sue someone for offensively, but you can also sue someone defensively. That's what I wanted to say. All right. So you can sue someone, for example, because they've committed a wrong against you. For example, defamation, right? So that'd be suing on the offensive, right? I'm suing you in an offensive way. I'm the one filing suit offensively. I'm starting the lawsuit offensively, right? And that's most of your lawsuits. Almost all your lawsuits are, right? I'm suing you for something you did. I'm on offense and I'm suing you. All right. But this is kind of different because this is sort of a defensive lawsuit that's being filed by them. So it's like I'm starting it, but I'm sort of on defense, kind of, because it's declaratory judgment, right? Instead of I want to sue you rather for something, I just want something to be declared to be true. Namely, I don't have to pay. And you can do this if there is a live enough controversy. So you'll see this most commonly, for example, in a cease and desist letter. Cease and desist letters have actual legal consequence to it, and this is one of them. Because if you send someone a cease and desist letter and say, if you don't stop this, I'm going to sue you, that's considered sufficiently provocative that the other person can say, well, I'm going to sue you first. And so they get to act defensively, right? Rather than wait to be sued and bring their defenses, they can just bring their defenses in the first instance. So that's what we're doing, right? We're bringing a lawsuit basically in a defensive capacity. Rather than wait to be sued and bring in our defenses, we're bringing our defenses in the first instance. And we're doing it because there's sufficient controversy in play that we can do that. I hope that made sense because declaratory relief is a little bit different than other kinds of lawsuits. So I wanted to talk about that for a minute. In any case, that's what we're doing. We're doing a declaratory lawsuit, right? This implies, and maybe they'll get into it, this implies heavily that there's been some sort of correspondence between these parties up to this point. And Amber Heard says something to the effect of, if you don't pay me, I'm going to sue you. So rather than just wait, they're going to sue first. Okay, so that's kind of what we're doing. All right. So we're in United States federal court. We have a diversity of parties because the insurance company is a New York corporation. Amber Heard is a California resident. That's a complete diversity of parties. We're suing in California, which is her home state, which is a perfectly appropriate place to sue. We might be able to sue somewhere else, but we can definitely sue her where she lives. That would be fine. All right. So we want some declaratory relief. New York Marine is some kind of insurance company. Heard is some kind of person. All right, so here's some allegations. New York Marine Insured issued a policy to named insured Under the Black Sky Incorporated and Amber Heard. So Under the Black Sky is some sort of holding company or production company or whatever Amber Heard runs, fine. For the policy period with a per occurrence limit of $1 million. A true and correct copy of the policy with premium and address is attached. The policy includes comprehensive personal liability coverage, part of which covers damages because of bodily injury, property damage, or personal injury caused by occurrence in which the coverage applies. The policy defines personal injury to mean injury other than bodily injury, arising from one or more enumerated offenses. Okay, so we have bodily injury as a separate category of thing. So we have bodily injury as a separate category of thing, and then we also have personal injury, which means not bodily injury because it's defined somewhere else, and also means oral or, among other things, oral or written publication of material that slanders or libels a person or organization, including other forms of defamation, and oral or written publication material, including other forms of defamation, violates a person's right of privacy. So one of the things what we're going to cover one of the things, or at least one of the things that constitutes a personal injury, one of the things that constitutes an injury is defamation and invasion of privacy. These are things that falls within the definition of a personal injury. Fine. Great. Let's read some more. All right. So now we have to cover the basics of why is there a potential claim, right? Now that we've discussed what a personal liability is, why is there a claim? Well, you guys kind of know the answer to that, but we're going to read it anyway. On March the 1st of 2019, Depp filed a lawsuit against Heard in Virginia. In the underlying action, that would be the lawsuit from Depp versus Heard, Depp sought and is seeking damages for defamation based on an op-ed allegedly written, you don't really need to write allegedly at this point, but whatever, written by Heard and published in both the online edition and the print edition, which is republished by Heard in a tweet. A true and correct copy of the complaint filed by Depp is attached as Exhibit B. So we're going to tell this court, hey, by the way, just in case you're unaware, there was a lawsuit filed by Johnny Depp. Here's a copy of it. On or about September the 4th, 2019, Heard tendered the underlying action to New York Marine. So September the 4th, 2019, Heard says, hey, insurance company, looks like I'm being sued, and I want to let you know because you need to pay out. Fine. On October the 1st, 2019, New York Marine accepted Heard's defense under underlying action subject to some sort of reservation rights. So we'll defend you, but ... Specifically, New York Marine advised Heard that New York Marine would provide legal defense, but to the extent that California law does not permit an insurer to indemnify the insurer, no indemnity can be provided. So they agree to pay for her legal expenses, which I imagine are massive. And probably more than $1 million. I don't know whether or not they're going to get into whether or not they've exceeded $1 million or not, because it was $1 million per occurrence. But one of the things they were willing to do is they were willing to fight for her. Whether that $1 million is separate from or not, maybe we'll get into it. But they're willing to fight her case for her. Now, indemnification is we got your back on the damages. That's indemnification, right? You were responsible. We've got your back. That's indemnification. So it's like, we'll protect your lawsuit, but we might not be willing to indemnify you. We'll help you win. We'll help you try it in court, but if you lose, you might be on your own. All right. At the time that Heard tendered the underlying action, the law firm Canyon McEvey was defending Heard. While New York Marine accepted Heard's defense, New York Marine agreed to continue the defense of Heard through the California law through the firm. New York Marine as informed and believes on such information and belief that Heard or his agents instructed other firms defending Heard in the action not to include Cameron McEvey in Heard's ongoing defense. So at some point, she was represented by one law firm, and Heard apparently told other lawyers not to cooperate with those lawyers, which at the time were representing her. So she's instructing other lawyers not to cooperate with her own counsel. Okay. I mean, given it's Amber Heard, sure, that sounds like a thing that's possible. As a result, on or about November the 2nd, the firm withdrew from the defense. I bet they did. That's the kind of thing that would, cause me to withdraw from a defense if I were a trial lawyer, right? If you hire me to be your lawyer, and then you instruct other law firms not to cooperate with me, you're the one instructing them, you are somewhat interfering with my ability to represent you. So I'm going to fire the client, right? You can't hire me and then turn around and say, hey, don't cooperate with the lawyers I just hired. It's like, well, you either want me or you don't. Apparently you don't want me, so good luck, I'm out. I'm outsies. Totally understandable. The underlying action began on April the 11th, 2022. It was only April the 11th, guys. It was only April the 11th. It wasn't even 3 months ago. This started. It feels like a long time ago, though, doesn't it? On May the 27th, the court issued jury instructions, which are attached as Exhibit C. In the jury instructions, the court instructed the jury with respect to liability. They must base the facts on as you find them and all the law contained in the instructions. The jury instructions also instructed the jury with respect to liability issues for Depp against Heard. The issues for which the jury to decide were the following: whether Heard made some statements and whether they were defamatory. As a finding instruction, the court in the underlying action instructed the jury that it shall only return your verdict for Depp for defamation if Depp has proved by greater weight of the evidence that Ms. Heard made the following statements, which they are individually. The statement was about Depp. The statement was false. The statement was defamatory implication. Defamatory implication was designed and intended by Heard due to the circumstances that conveyed the defamatory implication, and that it was made with actual malice. All right. And then we're going to go through the other two statements just to recite them explicitly, but it's the same thing we've said before, so fine. Yeah, so the court in the underlying action issued a nearly identical finding instruction for each of the other two statements. The jury in the underlying action returned a verdict in favor of Depp for all counts based on all three statements. The verdict was incorporated in a judgment order which was entered by the court on June the 24th. A true and correct copy of the judgment is contained below. As detailed in the special verdict form with respect to the statements at issue, the jury found Depp has proven all the elements of defamation. So they made all these individual findings explicitly that they were asked to, because that's what made it, incidentally, a special verdict form. If you guys will remember, it was called a special verdict form. I know this is going a while back, but they called it a special verdict form. What makes it a special verdict form is that they didn't just ask the bottom line question, like, do you rule for one side or the other? They asked a bunch of sub-questions. So now it's a special verdict because we want more specific answers. Okay, fine. So after answering yes to all those things, the jury answered yes to, did you find actual malice? The jury has awarded $10 million in compensation and $5 million in punitives. However, punitives were reduced to $350,000. Hence, liability for $10.35 million. All right, so those are the basic facts. We don't really need to say much more about that. That's great. All right, so what do we want? Well, we want some declaratory relief, as we said, right? So again, now what is not stated here in this cause of action, and it's a little bit sloppy in my opinion, is they are not stating why they think they have declaratory relief, because maybe they'll get into it. Maybe it's a function of law, but even if it is, I don't think it gets you standing in federal court, right? Declaratory relief only applies if there is a sufficiently live controversy. So I can't sue you in a defensive way just for the hell of it, right? So let's say that, you have a theoretical cause of action against me. The mere fact that you have a theoretical cause of action against me is not enough for me to file for declaratory relief. It has to be more. The threat has to be more material, has to be more real. And again, one of the classic ways you get there is through a cease and desist letter. Because if you don't stop, we're going to sue. Oh, that makes it much more real now, right? So you need something like that. You need some sort of thing that is giving you the basis for declaratory relief. Now, what they didn't state in their cause of action is what that is. So we may have a fight about whether or not we get to say boo, because maybe there's not enough of a live controversy yet. All right, so we'll see how that goes, I guess. All right, so California Insurance Code provides for the following. Insurer is not liable for a loss caused by willful act of an insured, but is not exonerated by negligence of the insured or the insured action agents or others. This provision is an implied exclusionary clause, which by statute is read into all insurance. Correct. Yeah, we are not responsible for willful acts. That makes total logical sense. The jury's factual finding is that there was willful acts. That is the nature of the thing, yes. As a result, as a matter of California public policy and pursuant to law, the policy does not provide coverage for Heard's liability as reflected for the judgment order. That sounds totally true. An actual current controversy now exists. This is not quite. I see this. I don't think that it does. It's not yet ripe. You need a little bit more, right? If there needs to be some sort of fight to bring it to life, the mere fact that we're on the hook to pay is not enough. Right? Some sort of demand letter from Heard would do the trick, right? You must pay me. If you don't, I'm going to sue you, blah, 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 right? But the mere fact that is not enough. So I don't think this works. I don't think they're standing yet. An actual controversy as written now exists between plaintiffs. No. on the one hand and Heard on the other hand with regards to duties and obligations owed between plaintiff and Heard under the policy with respect to the judgment. There is a potential controversy, but there's not an actual controversy. Not yet. The plaintiff contends that it has no duty to identify Heard for the judgment and is informed to believe in such information that Heard disputes the contention and asserts the policy provides indemnification. How? This is the part where you're weak. How? Information belief that they assert that Heard is disputing that. You can't just wish it into existence. Non-declaratory relief. You can't just wish it into existence. And you're wishing it into existence. So if there's nothing more here, this lawsuit will fail. Due to actual and present controversy described above, the plaintiff requests judicial determination of rights, duties, and obligations. A plaintiff has no obligation to identify Heard for the order. Yeah, no. They think there's a potential controversy because they think that Heard will want them to pay, and they don't want them to, and they don't want to pay. But it's not yet ripe enough. Heard has not, at least according to them, formally asked for the money. She filed she gave him notice of the complaint way back when, but they're not saying, hey, Heard said, give me $1 million. You owe me $1 million now. They're not saying like anything like that. They're just like, oh, there's a controversy because she'll want money, but she hasn't asked for money yet. She probably will, but it hasn't happened yet. And you can't sue on speculation. You have to have a live controversy. So, yeah. The code says the insured is not liable for loss caused by the uninsured by the other. For willful at once, as a matter of policy, does not provide coverage. Actual controversy has arisen? No. Due to actual controversy needs a declaration of rights? No. Third cause of action, relief from plaintiff's duty to defend Heard in underlying action. Okay. Because judicial factual findings regarding Heard liability from having any obligation to defend them in the underlying action, but the underlying action's over now. So what duty to defend are you even talking about? This doesn't even make sense factually. It's like, yeah, we don't have a duty to defend because the jury found her liable. Yeah, but if you had a duty to defend, what would that be even at this point? Because the jury has already found her liable. So this is even worse because I'm not even sure there can be a controversy. Because Amber Heard can't say defend me because that already happened. Or not. Either way, it's moot. This is strange. This is a strange thing. I guess throw it in there anyway, but it doesn't make sense. An actual controversy has arisen. I don't think it can. Due to the controversy, no. Declaratory relief as to duty to defend Heard in the underlying action about the policy for conditions. Okay, so one is based on the insurance code. One is based on the actual policy itself. That's fine. But no. Declaratory relief as the duty to indemnify Heard from any judgment. Declaratory relief as to deny Heard for the judgment order under the policy. So there's like multiple different ways that they might have to pay, and we don't want to pay for any of them. All right, so yeah. So therefore, we want judgment saying plaintiff has no duty to identify Heard. Plaintiff has no duty to identify Heard. Plaintiff has no duty to defend Heard. Award costs? No. Why would you be able to get costs? No. And grant such other relief? No. So this lawsuit is not going to go anywhere. It can't. There's no standing yet. Right? They're not saying Amber Heard has injured us. It's not she did something to us and we're suing her for something she did. Right? Like she committed some tort against us or has committed a breach of contract against us or something. We're not suing for something she did. We're suing for something that she wants us to do. But she doesn't want you to do it. At least she hasn't said that yet. You're just saying that she wants it. But you don't know that she wants it. I mean, she probably does because $1 million would be nice. But even if she asked for $1 million, it wouldn't be a controversy. It wouldn't be enough. Right? So even if she filed a claim, it wouldn't be enough to create a controversy. Right? Because people file claims all the time. on insurance, and most of the time the insurance company says no. Then we get into a lawsuit because now there's a live controversy. So even if she filed a claim, until the claim is denied, there's no controversy. I mean, because they haven't said no. They're saying that they would say no, but they haven't said no. It's all in the future. It's all future looking, right? Have they denied a claim from Heard? No. Not according to them, they haven't. Right? They haven't said Heard asked for money and we said no. They didn't say that. They didn't say Heard asked us for money. They're speculating what Heard will do or not, and they're also speculating about themselves, about what they would do or not in the future. In the future, we would say no if she asked. Well, you don't know that, strictly speaking, because you might change your mind for, I don't know, reasons. It's too speculative. It's not grounded enough. So the answer to this lawsuit is fairly easy. This lawsuit loses on standing. It's not a sufficiently live controversy. It is not ripe at this time. And even if she filed a claim, it's not enough, because merely them saying no is the contract, right? I want you to pay me. Even if that she says that, that's not a sufficient controversy. Until they say no, and until she says, if you don't say yes, I'm going to sue, that would do it. The thing is they want to preempt this thing, and they can't. They want to preempt and they can't. They have to wait. They have to wait until they're sued. Wherever that would be. New York would be obvious because they live in New York, or wherever the policy says, but they want to sue first and no. So, it's disappointing. But we might see some motions. We'll see some motions, and I guess we'll follow it. And I guess it's also possible that, for whatever reason, Amber Heard won't bring any of this up. And she's like, I want the issue. But even if she does, the court still has an independent duty to decide subject matter jurisdiction. Because this is a subject matter jurisdiction issue, whether or not they can sue. Because the courts, federal courts under Article 3, only have the power to decide cases and controversies. That's what Article 3 says. The federal courts only have the power to decide cases and controversies. The courts do not do advisory opinions. Very famously don't in the U.S. system, right? They don't do advisory. So even if Amber Heard doesn't raise the issue in any of her filings, it still doesn't matter, because the court has an independent obligation to ensure subject matter jurisdiction. Subject matter jurisdiction, also incidentally, for what it's worth, is one of those issues that cannot be waived. In fact, it's basically the only issue that can't be waived, is subject matter jurisdiction. You know how we normally talk about you use it or you lose it? Like for objections or other kinds of things like personal jurisdiction or defenses or objections or whatever. Like we talk a lot about how if you don't use it, you lose it. Like if you don't raise it, it's gone. If you don't bring it up to the trial court, it's gone. You can't bring it up for the first time on appeal. Subject matter jurisdiction is the quintessential exception to that rule, because it can't be waived, because it goes fundamentally to the fundamental power of the court to hear the issue. And if they don't have power to hear the issue, well, that's kind of something that's raisable at any time. It has happened at least once, and I can't cite you the case, but it has happened at least once where at the U.S. Supreme Court, where no one raised the issue of subject matter jurisdiction. Never happened. Never mentioned at the trial level. Never mentioned at the appellate level. Hell, it wasn't even mentioned at the Supreme Court level. No one mentioned subject matter jurisdiction anywhere in any of their arguments, in any of their briefs, in any of their oral arguments. Nada. And the Supreme Court said, subject matter jurisdiction, it's gone. Because they have an independent duty to raise that issue. So it's something that can't be waived. So even if Amber Heard wants this lawsuit, like until she does something to provoke it, it's moot. So it can't survive. And if it proceeded, until it's actually final, it's gone. Because again, you can raise it at any time. So the whole thing is stupid. Because even if no one raised the issue, and it somehow got into some sort of resolution, and we went to appeal, and somehow got into some kind of resolution, until it's like truly final, you could just be like, oh, there's no subject matter jurisdiction. The court would be like, you're right, oops, none of this happened. It's all poof. It's all fugazi, right? It's all an imaginary thing. So that's kind of annoying. So I applaud their attorneys, I suppose, for wanting to be done of it, but they can't preempt this. They have to wait. All they can do is send a letter to Amber Heard saying, we are not going to give you money. We are not going to give you money under your claim. Go away. And then all they can do is either wait to be sued or wait for Amber Heard to send back some sort of cease and desist kind of equivalent letter. And then they would have basis for declaratory relief. They can't act first. So, nice tries and all, but no. So, yeah. Someone said, could this be to try and set venue? No. Venue's not a problem. Venue also, incidentally, is not an exclusive thing. There are potentially multiple different places where jurisdiction is proper and or venue is proper. So, if you're looking for places where, like, this could be heard, well, California is a place where this could be heard because Amber Heard lives there. Incidentally, Amber Heard presumably would want to be sued if anywhere in California because she lives there. That would be presumably the most convenient place for her to be sued. So, yeah. But venue might exist somewhere else. I mean, it would depend on the contract. Venue can be set by the contract and often is. It's like, this case shall be heard in wherever. So there might be multiple different places venue, but can it be used to set venue? No, because there's no subject matter jurisdiction. So even if the court ruled venues here, and there's personal jurisdiction, which there is, it looks like. Personal jurisdiction is not an issue. So this is different in that respect from, for example, for Toddy from Without a Crystal Ball. Personal jurisdiction is not an issue. We do have personal jurisdiction. We have sufficient minimum contact. She lives there. So personal jurisdiction is not a problem. Subject matter jurisdiction, though, is a massive problem. The court can't hear this case. They don't have power to hear the case. So, yeah. Could it be noticed that they won't pay? No, they can't bootstrap themselves into it. And even if it was noticed that they can't pay, it doesn't provide the controversy. Because merely sending the letter doesn't provide the controversy, right? Because if they sent a letter to Amber Heard saying the equivalent of, well, we're not going to give you money, Amber Heard could say, well, okay. And then there's no controversy. I mean, that seems unlikely, but she can. Right? So you don't know. Maybe she's seen the light. So they can't bootstrap themselves because they don't know what Amber Heard was going to do. Maybe they send a letter saying, we're not going to give you the $1 million. And Amber Heard says, oh, I totally understand. Yeah, that's right. Okay, we're good. We're good, you and me. We're homies. They don't know yet. They're guessing. They're speculating into existence. You can't do that. Hamilton gave $4.99, said, will there be blowback? As Amber Heard testified in court, she was paying attorney's fees. Why she couldn't enter her pledges? She didn't exactly say that. She said something like, well, she said that she couldn't give the money because she'd been sued. She didn't say it was because she was paying attorney fees, I don't think. I think she said something like she couldn't pay the money because she was getting sued, potentially because she was prospectively worried about not having money down the road, which is neither here nor there, but whatever. Ray wins all. So her lawyers were paid through insurance? It certainly seems that way, yes. T in Tennessee gave $4.99, and then T in Tennessee gave me some hippos emerging out of water. That's badass. Petrograph became a new member. Thank you very much for hitting that beautiful join button.